This narration script is for https genineural en audio. File, largoen.mp3. Article, D9-Queen-Protege-EU-Corte-Trump-2026-06-06-30.md, approved Pepe Grillo. Command, https voice nus genineural file v1 script narration en.txt write media audios/largoen.mp3. Editorial opinion, News Miami-Dade. Cover. The Supreme Court closed Trump's shortcut. Birthright citizenship returns to Congress. June 30, 2026. The 6-3 ruling, 2 arguments, 1 consequence. On June 30, 2026, the Supreme Court ruled 6-3. Trump's Executive Order 14160, signed on the first day of his administration, was struck down. The order sought to eliminate automatic citizenship for children born on U.S. soil to parents without legal immigration status. 2 separate arguments, but the same outcome. 5 justices, Roberts, Sotomayor, Kagan, Barrett, and Jackson, said the order violated the 14th Amendment directly. The text of the Constitution is clear: all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens. A 6th Justice, Brett Kavanaugh, agreed the order must fall, but on narrower grounds. He said it violated federal law, specifically 8 U.S. Code 1401, This difference between the 5 and the 1 will define the next chapter. From Minute Zero, the most valuable door. This editorial poses a question the ruling cannot answer for us. Crossing the border without legal authorization is a federal crime under 8 U.S. Code 1325, from the first step, from second zero. That act, a federal misdemeanor punishable by up to 6 months in prison on the first offense, triggers a consequence no other nation with similar immigration challenges maintains in its constitution: the child born on that soil automatically becomes a U.S. citizen. A U.S. passport. Federal benefits. The right to vote at 18. Pew Research documented in 2022, 4.4 million U.S.-born children have at least one undocumented parent. The question is not whether those children deserve dignity. The question is whether the Constitution was designed to make the act of violating the law the most valuable door in the system. The 14th Amendment, was it designed for this? To understand what the court protected, we must understand what the 14th Amendment was written for. 1868, 3 years after the Civil War. 5 years after the Emancipation Proclamation. The Dred Scott decision of 1857 had ruled that people of African descent, whether enslaved or free, could never be U.S. citizens. Congress wrote the 14th Amendment to fix that historic injustice. To guarantee that the descendants of enslaved people were citizens, without condition, without permission from the states that had enslaved them. In 1898, the Supreme Court decided Wong Kim, Arkansas. A man born in San Francisco to Chinese parents, who were legally residents but ineligible for citizenship under the Chinese Exclusion Act, was ruled a U.S. citizen by birth. That ruling has stood for 128 years. The Supreme Court did not formally reverse it on June 30, 2026. But the 14th Amendment of 1868 was written in a world where illegal entry did not yet exist as a federal crime. 8 U.S. Code 1325 would not be enacted until 1929. The category of illegal immigrant barely existed. The question that no court has resolved, the one that now moves to Congress, is this: does the text written to fix Dred Scott also apply, without any modification, to a reality that did not exist when it was written? The dissent, a map for the next chapter. 3 justices dissented: Thomas, Alito, and Gorsuch. 1/3 of the Supreme Court agreed that the executive order was not unconstitutional on its face. Justice Alito called the majority reading a serious mistake and a medieval rule, a phrase that will live in legal scholarship. The dissent does not make a new rule. It cannot. But it tells us something critical: the argument reaches 3 of the 9 most powerful judges in the country. It is not a fringe position. And Kavanaugh's concurrence opens a door the dissent left half open. Kavanaugh said Congress has authority to reform the statute, 8 U.S. Code 1401, that defines who is born a citizen. Without a constitutional amendment. Without the 2/3 of Congress and 3/4 of states that a formal amendment requires. Does Congress defend the nation, or benefit those who break the law? Since 1998, at least 11 bills in Congress have proposed limiting or conditioning birthright citizenship. None has passed. The SAVE Act, Safeguard American Voter Eligibility Act, passed the House recently. But it is about voter registration, not citizenship. They are two different things. The question is not whether Congress can act. The question is whether Congress is willing to. And if it is not, as it has not been for 28 years, who benefits from that inaction? The answer is not the American people. The global map, 33 of 195 countries. The Law Library of Congress documented in 2018 that approximately 33 of 195 countries maintain unrestricted just solely, the right to citizenship by birth regardless of parent status. The majority are in the Americas. Most of Europe, Asia, and Africa restrict just solely. The United Kingdom limited it in 1981. Australia in 1986. Ireland voted in a constitutional referendum in 2004, with 79% in favor. All of them did it by legislation, by democratic process. Not by executive decree. That is what the Supreme Court said on June 30. The goal may be legitimate. The method, a presidential executive order on day one, was not. Miami-Dade, epicenter of the federal debate. Florida has an estimated 1.2 million undocumented immigrants, according to the Congressional Research Service, making it the third state in the country. The CRS also estimates between 150,000 and 300,000 babies are born each year in the U.S. to parents without legal immigration status. For Miami-Dade, the most foreign-born county in the state, this ruling is not abstract. WLRN documented the testimony of a South Florida woman, we will call her Michelle, who said, "We are stressed and worried about an unborn child's legal status." That testimony represents hundreds of thousands of families in this county who lived under the uncertainty of Executive Order 14160 for more than 17 months. The court resolved the uncertainty. But it did not close the question. The phenomenon of birth tourism, a documented but distinct reality. Executive Order 14160 cited birth tourism as part of its justification. The phenomenon is real and documented. In 2019, the Department of Justice indicted 19 people in California for operating birth tourism networks, where foreign nationals paid between $40,000 and $80,000 to give birth in the United States, obtaining citizenship for their children. The State Department issued regulations in January 2020 to restrict B visas for pregnant women suspected of traveling specifically to give birth. But birth tourism, a largely middle-class and upper-class phenomenon from Russia, China, and South Korea, with a documented paper trail, is legally and demographically distinct from undocumented immigration. Treating them as the same problem in one executive order was part of what made the order legally vulnerable. Who benefits from the status quo? 128 years without formal revision. 28 years of failed congressional bills. Courts consistently blocking executive action. Who benefits when birthright citizenship remains exactly as it is? Not the American taxpayer, who absorbs costs never calculated with transparency. Not the immigrant who entered legally, who sees the rules applied unevenly. Not the undocumented immigrant, who lives in legal limbo that birthright citizenship for their child does not resolve. The only clear beneficiaries of permanent inaction are political actors, on both sides, who prefer birthright citizenship as a campaign tool to birthright citizenship as a resolved legal question. What did the court protect? Chief Justice Roberts has written that citizenship is the right to have rights. On June 30, 2026, the court protected that right for the 4.4 million U.S.-born children with undocumented parents, and for the thousands born in the coming years. But the court did not protect the political or policy question. That question, whether the 14th Amendment needs to be updated for a reality that did not exist in 1868, the court explicitly left to Congress. What did Trump protect? Executive Order 14160 was titled Protecting the Meaning and Value of American Citizenship. On April 1, 2026, Donald Trump became the first sitting president in 237 years to attend oral arguments at the Supreme Court. He lost 6-3. But he convinced 1/3 of the court. That is not nothing. Trump's argument reached Alito, Thomas, and Gorsuch. It did not reach the majority. The question the ruling cannot answer is this: was Trump protecting his citizens, or his political agenda? History will judge that. What is certain is that the method failed, and the Constitution is still standing. The lesson: the rule of law in action. 3 lessons from June 30, 2026. For Trump, 3 justices agreed with you. The method was blocked. The right channel exists: Congress, constitutional amendment, democratic process. For the American people, the system of checks and balances worked. A president signed an executive order on day 1. The courts reviewed it. The Supreme Court struck it down 6-3. That is the rule of law functioning, even when it is uncomfortable. For the 14th Amendment, it fulfilled its original mission. It protected citizenship from executive unilateralism. It is now time to update it, through the correct channels. The Congress writes the next chapter. If it has the courage to do so. This editorial analysis was produced by News Miami-Dade, newsmiamidade.com. 26 verified sources. All claims anchored to primary sources. Editorial opinion. News Miami-Dade does not represent any political party or electoral candidate.